This is Michael Popok, Legal AF. Lots of developments in the civil fraud case in New York against Donald Trump, including his attempt for the third time to stay the case, get the case declared a mistrial, take an appeal on his gag orders, attack the judge and the law clerk. We talk about it all, and we debate it on the most recent episode of Legal AF with me and Ben Meiselas. Take a listen.
Tell us about this mistrial motion that Judge Engoron very swiftly disposed of, Michael Popok.
So swiftly, the judge didn't need even full briefing on this particular motion. Just to explain New York practice, you make a letter request to the judge first about your desire, your intention to file a motion. And then you can, that's your letter brief, we call it. It's not your actual motion. And you, in this case, you attached in New York, because we have a kind of a unique Byzantine style here that dates back to the early or the late 1800s. You do it by way of what's called an order to show cause, where you propose a briefing schedule, a return date, we call it, for the brief and then for the hearing, and you submit that to the judge. The other side, in this case, the New York Attorney General, can submit a letter brief in opposition to the request to file the motion. It's a little complicated, but that's what happened. And then the judge took one look at the letter briefing and the foundation for the mistrial motion, which is primarily the following. We don't like Judge Engoron. I don't know why I'm getting those two confused today. We don't like Judge Engoron. Judge Engoron is mean to us because he doesn't rule in our favor enough. He rules for the other side more than for us. He's got a law clerk that's a Democrat, and she ran for judge. And we don't like the fact that they do their job together the way a law clerk is supposed to support a judge. And we observed all that. The judge runs a newsletter for a private school that he used to be a part of and likes to post not commentary, but likes to post the links to the articles about the case there. And we think that shows bias. He's got some pictures of himself with his shirt off that seem to drive them a little bit crazy. For whatever reason, they love doing that. And this was the grounds, and that the judge made a statement that they've taken completely out of context, to which the judge found bad faith that they even raised that issue. And I'm going to talk about what I think will happen next related to the lawyers in the room making a bad faith comment about a judge, because that's not a good thing under the ethics rules. Talk about that in a minute. And the judge said, okay, on that one, I said, here, I'll read it. Let me just read it. I have it here. To the extent defendants argue that I have exhibited bias, and this is on page 5 of 6 of the order, by stating in court that, quote, I'm not here to hear what Donald Trump has to say, close quote. Such argument is disingenuous and made in bad faith, as defendants omitted what I said immediately after that sentence, which is, I'm here to hear him answer questions. Indeed, that's precisely the role of a witness and the finder of fact, meaning when he was pontificating, Donald Trump, in response to every question and getting on his soapbox with his canned answers and not answering the question. And the judge said, this is really irrelevant. If there was a jury present, the lawyer would have instructed asked the judge to strike the testimony from the record, so it's not part of the record for the jury, and to instruct him to answer the question that's been asked. When you have a bench trial with the judge as the trier of fact, he doesn't have to go through that rigmarole. He can just say, answer the question. We don't need your narrative. And he said, I'm not here. And that's when Chris Keiss stood up with Alina Habba and said, it's just a lot easier, Judge, if you just lay back and let him talk. It's just a lot easier. He is the former president or the president or whatever they like to call him. And the judge said, I'm not here to hear him talk. I'm here to hear him answer questions. They cut that in half and use that. Here it is here. They use that against the judge in every filing that they've made, including in the federal court and the federal courts of appeal. The bad faith reference is a bad thing for Habba, Keiss, and Cliff Robert, because the judge can do one of two things. And he can do it right now. He can't threaten to do it, but he can do it. He can make a referral to the appellate division, first department, which supervises all lawyers that practice in that department, and make a ethical violation referral that they've used bad faith now the second time against the judge in their filings. That's a bad thing. For those in the courtroom that are not already members of the New York Bar, like Cliff Robert, but are there by permission under what we call the pro hoc vici rules or the special admission rules, the judge can pull their ticket and say, you know what, Alina Habba, you know what, Chris Keiss, you've lost your privilege to represent your client here because of how you've acted. I'm not sure he goes that far because now he's getting in the middle of that sacrosanct relationship between a lawyer and a client. But I don't think this ethical violation will go unnoticed by the judge. He used that word particularly for a reason. And then my other favorite part of the decision, which he denied the motion for mistrial, he says, I don't even need full briefing. And then he said to the New York Attorney General the following on page 5 of 6. Plaintiff, this is the New York Attorney General, has advocated for a full briefing schedule on the mistrial motion, emphasizing that although it believes defendant's motion is without merit, it also believes briefing would economize the timing and effects of any appeal. And the judge made this withering response. However, in good conscience, I cannot sign a proposed order to show cause that is utterly without merit and upon which subsequent briefing would therefore be futile. And he says, I've looked at all of your basis for mistrial, and it is denied. My relationship with the law clerk is appropriate and ethical. She's not a co-judge. All the decisions I make are mine and mine alone. But in a little bit of a commentary here, you've got a judge, and I know these lawyers have never done this before, I have, who's got a 8, 10, 12-week trial. He is the only trier of fact. Okay, he can only scribble notes so much during these days with, the New York Attorney General put on 25 witnesses. I assume Donald Trump will put on a dozen or more witnesses. There are hundreds of thousands of pages of exhibits. Even the jury has other jurors to rely on when they deliberate about what did your notes say? What did you think that guy said? And they have all the transcripts. The judge uses his staff the way a partner in a law firm uses his associates in order to help him keep track as the trier of fact of all the information and to ultimately render his decision. The decision is the person in the black robe, but that doesn't mean he can't consult with people sitting next to him. And they keep, even in the, we'll get to it when we get to DC a little bit, Ben, they even put that photo again in the DC gag order to raise an entire section of attacking the law clerk again. All it shows is willful blindness and a misconception and a misreporting of the relationship between a judge and a law clerk under New York law. Okay. And at the beginning, I thought, well, this is just ignorance because they don't know any better. No, they're doing it on purpose because they got nothing else to talk about because they're losing. Let me just say it out loud. They are losing the case in the courtroom. I can't put this on finer terms. Within the 4 wood paneled walls of the courtroom where it matters, not outside, where the game is played, they are losing and losing by a lot. Right? Those 25 witnesses were devastating for them. The evidence with Donald Trump's signature on it, devastating for them. The adverse witnesses that were brought in that were former employees and felons, or those that just avoided being felons by getting immunity and his own children, devastating. And if their first witness to try to turn around this battleship in their direction is Don Jr.'s, play school PowerPoint, they are dead. And so that's why you see the flailing and the bashing and the attacking, because they are losing in the courtroom.
And that's a microcosm or a microcosm of everything that Donald Trump does and that all that MAGA does. I mean, talking about the release of these January 6th additional tapes, right? What was their first instinct? They gave him, what Kevin McCarthy do? He gave him to Tucker Carlson so Tucker Carlson could filter him. And now they're releasing it, but they're redacting the faces of actual insurrectionists. So people who are involved in the insurrection are being protected by them. And then the MAGA people are like clipping small portions of them and then acting like, oh, look, you see, they were not violent at this moment. So therefore, let's go after the January 6th committee. It's all bad faith. And what really makes me angry about it and should make you angry about it watching that is that they are trying to manipulate us. They are trying to play us. And when legacy media is lazy and allows them to do it, they're aiding and abetting that manipulation of us with very disastrous consequences for our nation. And that's why, for me, this show, what we talk about here on the MeidasTouch Network, is just give me the full facts. Look, Popok, if Judge Engoron actually said, or any judge said in a proceeding, sua sponte, on their own, to any litigant, I'm not here to listen to what the party has to say, get out of here, I would be really upset about that. I would say to myself, that's a corrupt judge. The judge, how horrible. But that's like someone telling you the first part of the story, but not telling you how it ends. And that's the lie. What Judge Engoron said was, I'm not here to hear what Donald Trump has to say. I'm here to hear the answers to the questions. I'm here to listen to him answer the questions because this is a trial. So when he's being cross-examined, I'm not here to just listen to him rant and rave and read letters and go on tangents that are not related to this. If you want to ask him in direct examination, which you didn't do, Alina Habba and Trump's lawyers, ask him direct examination question. This is cross-exam. I'm here to listen to him answer the questions. And then the fact that Trump's lawyers had the audacity not only to make that their public talking point, and by the way, that may be all the public hears about it. People are very busy in their days. People have a lot going on. They're working sometimes multiple jobs. So they may only hear, wow, this judge said, I'm not here to listen. There may be something wrong with this judge. And they're not getting the full context. That pisses me off. It really does. That's why I do this. That's why we built this network. So I'm like, no. Tell me. Oh, the judge said I'm here to listen to the answers to his questions. And the Trump lawyer kind of arrogance with disinfo has reached such a level where they're like, okay, we're going to put this in a court filing. We're just going to lie about what he said. Even though there's a transcript, we're going to even put it in the court filing. Because you know what? We don't even care if we lose this case. So we don't care about we just care about, will the public create so much pressure?
Well, there is an example of what we do every week on Wednesdays and Saturdays at 8 p.m. Eastern Time on the MeidasTouch Network, exclusively there on a show that we call Legal AF. If you like that kind of content, join us every Wednesday and Saturday and pick us up on audio podcast platforms wherever you get your audio podcast from. If you know all about us, welcome back. If you don't know what I'm talking about, join the ride and join the movement. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.